Have you ever wondered what your HOA is really talking about in their emails? Well, what if you asked to see them and they just said no? Sounds a little fishy, right? That's the core of a real-life legal battle we're going to break down today, and it really all boils down to just one key question.
Yep, that's it. Is your HOA actually required to show you its private emails? You'd think it's a simple question, but it fueled a legal fight that went all the way to a judge. So let's follow the trail and see how one homeowner tried to get some answers. All right, so let's meet our main character. His name is Douglas Kupel, and he's a homeowner in the Hidden Valley Association out in Arizona. He basically got curious, wanted to peek behind the curtain and see what the board was talking about. So he did what you're supposed to do. He filed a formal request to see their records. So here's how it all went down. On June 22, 2020, Kupel sends in his request. Pretty standard stuff. A couple days later, the HOA's management company gets back to him and says, "Hey, can you resubmit this on our special form?" Okay, no big deal, right? A little bureaucracy. But then, on July 1st, the official response lands. And yeah, they give him some records, but the main thing he was after, those internal communications, the emails, were totally missing, completely withheld. So what was their reason? Why hold back? The HOA's official line was that the emails were legally protected from disclosure. Basically, they were saying, nope, we don't have to show you these. And that single no is what lights the fuse for this whole legal showdown. Now, Mr. Kupel wasn't about to just take no for an answer. He took them to court. And when he showed up for the hearing, he brought something he thought was a total game changer, a smoking gun, if you will. And the best part, it was evidence using the HOA's very own words against them. Check this out. This is the key piece of evidence. In an email, the HOA's own board president, a guy named Gary Freed, had literally written, "This communication has been received and will be filed as an HVA business record." Kupel's argument was just plain common sense. Hey, you called it a business record. The law says I can see business records, so show me the records.
I mean, that seems like a slam dunk, right? Case closed. The president himself put it in writing. But this is where the story gets really interesting and takes a turn you probably won't see coming.
Because what happens next is the HOA president, the same guy who wrote the email, gets up on the witness stand, and his story completely contradicts what he wrote. It sets up this incredible dilemma for the judge. What do you believe? What the guy wrote, or what he's now saying under oath? So under oath, President Freed lays out his defense. He says, first off, that line about business records, whoops, that was a mistake. He says he thought at the time that he was supposed to keep every single communication. Then, he claims that there weren't actually any responsive emails to show anyway, at least none that weren't legally protected. And to top it off, he says they barely even used email for business. Almost everything was done in open meetings. It's a bold move, basically saying, yeah, I wrote that, but I didn't know what I was talking about. So you've got the email on one side and sworn testimony on the other. How on earth does the judge decide which one wins? Well, to figure that out, we have to do what the judge did. Look at the actual law. What are the rules of the road here? Okay, so the law in question is an Arizona statute, and its whole point is to make sure homeowners have reasonable access to their association's records. Sounds simple, right? But, and this is a huge but, the law also carves out some pretty significant exceptions. So here's the stuff an HOA can legally keep under wraps. Number 1, any emails back and forth with their lawyer, that's privileged. 2, anything about pending lawsuits. 3, minutes from closed-door board meetings. 4, personal info about other members or employees, financial stuff, health records. And 5, stuff about employee job performance. The HOA's whole argument was that if any emails did exist, they fell into one of these buckets, so they didn't have to show them.
All right, so the stage is set. You've got Kupel smoking gun email on one side and the president's sworn testimony on the other. Let's get to the main event, the judge's final verdict.
But before we get to the decision, there's a really key legal idea you need to know. It's called preponderance of the evidence. In a civil case like this, the person bringing the lawsuit, in this case Mr. Kupel, has the burden of proof. He has to prove that his side of the story is more likely true than not true. Think of it like a scale. He doesn't need to prove it 100%, just enough to tip the scale even slightly in his favor, like 51%.
So this is what it all boiled down to for the judge. In one corner, you have the hard evidence, the literal words on a screen. In the other corner, you have a sworn statement from a human being saying those words were a mistake. What's more powerful, the text or the testimony?
And here's the kicker. The judge actually found the president's testimony to be credible. The judge's logic went something like this. Just because the president said in an email that it would be filed as a record, that doesn't prove that a record, a non-privileged, showable record, actually exists. The email was the only piece of evidence Mr. Kupel had, and it wasn't enough. He failed to tip that scale to 51%. He didn't meet the burden of proof.
So what was the final penalty for the HOA? A big fat 0. The judge found they hadn't actually broken the law, so they didn't have to pay a dime.
And what about Mr. Kupel, the homeowner who started this whole thing? Well, not only did he not get to see the emails, but he was also out the $500 he paid to file the case. The judge said the HOA didn't have to pay him back.
So, this whole case leaves us with a really fascinating question, right? In a legal showdown, what's more powerful? What someone wrote down or what they said later under oath? It's a classic battle of paper versus person. And in this particular courtroom, on this particular day, the sworn testimony was mightier than the email.